In our third case today, 2024-1409, Disciplinary Counsel versus the Honorable Timothy Joseph Grendell. I would like to thank Judge Edelstein from the 10th District Court of Appeals today for sitting on behalf of Justice Bruner. Thank you, Judge.
Of course, it's an honor.
On behalf of the respondent, Mr. Funk. Good morning.
May it please the Court, Stephen Funk, on behalf of the Honorable Judge Timothy J. Grendell, I'd like to reserve 3 minutes of my time for rebuttal. This case involves 3 separate and distinct counts and a very large number of legal issues, but I'd like to begin by first emphasizing why Judge Grendell is entitled to a ruling in his favor on counts 3 and 4, which raise a host of First Amendment issues that the Board of Professional Conduct refused to consider at all. And with respect to count 4, this court held in O'Toole that content-based restrictions on speech must be narrowly tailored to permit judges to speak on disputed legal and political issues, and that it therefore, I think, clear that Judge Grendell did have the First Amendment right to testify about House Bill 624 concerning the COVID-19 public health crisis. And when you look at Rule 3.2 and you construe it broadly to permit First Amendment expression, it's clear that I think Judge Grendell's testimony on House Bill 624 did involve the matter concerning the law, concerning the administration of justice, and the legal system. And you have to remember, at this time, this was in June of 2020, there was a lot of conflicting advice given to courts about how to handle the COVID crisis in its courtroom. So I think there's no question that the bill that was the subject of House Bill 624 would be a bill that would affect the legal system and the administration of justice. And so I think Judge Grendell is entitled to a judgment in his favor on count 4.
So, you know, the case law on this seems pretty clear. You know, the United States Supreme Court has said that the First Amendment, under the First Amendment, can't prohibit judges from announcing their views on disputed legal and political issues. This is clearly a disputed legal and political issue. Did you raise that with disciplinary counsel during the investigation, that this is protected conduct?
Numerous times. And we also moved for...
What was the response that you got?
Essentially, the response that the board provided is that that's going to be a matter for the court to decide, and it's not a matter for the Board of Professional Conduct to rule on. We asked the board, we moved for partial summary judgment in part because we wanted the court to construe the regulations consistent with the First Amendment, and they refused to consider that question. So that's why that's an issue of first impression for this court. And I do think that the First Amendment issue is clear. The case law is very clear. It applies not only to statements made during campaigns, but it would apply to statements made in front of legislative committees. And we've cited case after case in numerous states that have recognized that judges have First Amendment right on that question. Now, I do think that the court does not have to reach that constitutional question because I do think that his testimony falls within the scope of 3.2. And with respect to 1.3, that does raise First Amendment issue as well, because essentially what the board found was that Judge Grendell could not testify about House Bill 624 because his wife was a member of the legislature and one of 30 co-sponsors of the bill. And that just cannot be the rule of law. I mean, this court has recognized, the Chief Justices at least, in their disqualification opinions on Judge Grendell, that Judge Grendell and his wife are separate and autonomous individuals, and you don't lose your constitutional right to testify just because your wife is a member of the legislature or another member of your family. So I think that count 4 is easily resolved. But let me move to count 3. Count 3 it also involves First Amendment issues because they sanctioned him for providing comments at a Tea Party meeting in which the Tea Party asked him to come in order to respond to public damaging statements about alleged criminal conduct of his employees. So in order to protect the public confidence of the court, he went to that meeting to defend the integrity of the court, to defend his employees in the context of that Tea Party meeting. And this was really a political dispute that was initiated by the Geauga County auditor. This is a political dispute that has come before this court in terms of the auditor's refusal to sign warrants to pay the court expenditures. And this court ruled in a 7-0 opinion that the county auditor had a mandatory duty to pay those expenses. Now, when these events were occurring, this was in 2019, the auditor was not only refusing to pay the expenses, he issued a directive that said that Judge Grendell's employees could not even enter the public spaces of the auditor's office to do the public business. And so Judge Grendell had an obligation as the administrative judge to defend the court and to issue administrative orders as may be necessary to ensure that his employees can do the work that's needed to be done to get court-ordered expenditures approved. And what happened in this case was that county auditor called the police, the Chardon police, and told them that employees were trespassing in the auditor's office. The police come, but they quickly recognize that there's just no basis. The Chardon police quickly recognize there's no basis for the police to be involved in this dispute. And that's evident from the record. You have emails directly from the police chief where he says very early on that the auditor is trying to involve us in a political dispute. We should not be involved. The city prosecutor testified very clearly that he instructed the police not to intervene unless there was some evidence of threats of property damage or personal injury. So what happened here is that no charges were ever filed. No charges were ever brought by the police. And at the time of these communications, there were no pending charges. So there would not have been any violations of 2.10, which involves intervention.
Do charges have to be actually pending? It says pending or impending investigation.
Right, pending or impending. But at this time in June of July of 2019, there were no pending or impending charges. The police had actually made it clear that they were not going to intervene in this dispute. So the only issue of impending only occurred when the special prosecutor got involved. That was not until July of 2019, after these communications occurred. And
when was the newspaper article that was part of the Disciplinary Counsel's report?
The newspaper articles were in early July 4th and 11th of 2019. So the Tea Party meeting was before the special prosecutor as well. So at the time of these communications, there were no pending or impending charges. But the key thing is that Judge Grendell did not even know about the special prosecutor until well after the fact. And then once the charges were brought, they weren't bringing trespass charges because obviously that was meritless. They brought a charge for criminal mischief, which was quickly thrown out by the judge on a judgment for acquittal for one of the employees, and the jury in 20 minutes said not guilty for the other employee. So to then come back and allow these political opponents to not only use the disciplinary process to get retribution against Judge Grendell, but then to testify at the hearing that he was, quote, a bully who threatened contempt when they did not cite a single instance in which he's actually threatened contempt of an employee. And then to say that that testimony outweighed the testimony of former Justice Paul Pfeiffer, Representative Seitz, Lorain County Probate Court Judge James Walter, and 60 letters from other judges testifying to Judge Grendell's good character, I think shows a little bit of why the board mishandled this proceeding. So with respect to count 3, though, I do think that Judge Grendell is entitled to judgment in his favor because one, the First Amendment right on the Tea Party meeting, and then 2, no pending charges on the other part. So let me move to count 1. And I know that that's the balance of what the court's opinion is, or the board's opinion was about. This case involves Judge Grendell's handling of 1 out of the thousands of cases that he's handled over his 13-year career. And in fact, they're using this one case to judge his 46-year legal career in which he had no prior incidents of any discipline whatsoever. And this is a very difficult case involving evidence of parental alienation that the domestic relations judge was unable to solve and asked Judge Grendell to assist. And Judge Grendell could have said no, but he took it on. And it was a very difficult case. What he was trying to do was to implement an agreed judgment entry so that there already had been a resolution that the father was to get visitation rights. And yet it kept being stymied and stymied and stymied. So even when Judge Grendell gets the case, he's trying to get the agreed judgment entry going. And ultimately, he makes a decision that he will order the 2 children to go on a visitation with the supervision of the constable. And that's the point in time in which they are subject to detention. Now, I know there's a lot of disagreement by the board, vehemently disagreeing with the decision to detain the two individuals, and I can understand that. But the reality is that the law permits a juvenile court judge to detain temporarily juveniles on unruly charges. And we cite the statutes, we cite the 11th district cases in our opinion. The law does permit it. So what we have here is not a willful failure to follow the law, but just a substantive disagreement with how Judge Grendell applied the law and believing that he should have reached a different decision. And this court has held time and again, and most recently in Disciplinary Counsel versus Gall, that the failure to follow law in and of itself cannot give rise to a disciplinary violation, because otherwise, judges will be, would create an undue chilling effect on judges in making decisions. And so what this court held most recently in the Hoover case, and a number of courts throughout the country have reached the same conclusion, which is that unless there's a pattern of a willful failure to follow the law, we're not going to discipline a judge because they made a mistake in one case, or even an abuse of discretion, or even a severe abuse of discretion. We have remedies available through the court system for that. And when you look at the board's opinion regarding count one, what you find is they go through the proceeding and they find all the things that they think he did wrong, as if they were an appellate court, going through. And what was even most egregious of all of these things that they found was they found that the Judge Grendell erred because he applied the rules of juvenile procedure. Now, that was an issue that was raised sua sponte by the hearing officer, and it frankly is not consistent with the case law at all. The cases that we cite specifically say that the rules of juvenile procedure apply in a case where a case is transferred to the juvenile court pursuant to statute. And the cases cited by the board and the disciplinary counsel, in their opinion, are not on point at all because they don't involve transfers of cases from domestic relations to probate. And so Judge Grendell, notwithstanding that, the board found that he blatantly violated the law, even though there's case law supporting his interpretation that the rules of juvenile procedure applied. And the other thing, too, is that there were attorneys involved in these cases. Nobody objected during these proceedings to him applying the rules of juvenile procedure. And that was an issue that wasn't even raised until the middle of the hearing, on disciplinary counsel's hearing. So I would ask the court to consider the Michigan Supreme Court's opinion in Gorsica, I'm not sure exactly how to pronounce it. That was a case where a judge detained three children for 17 days for allegedly refusing to go on visitations with their father. And in that case, the court did find an abuse or a violation of the law, and yet they did not suspend the judge, but found, by looking at case law across the country, that it would have to be evidence of a willful failure to follow the law, and there just wasn't any willful failure to follow the law. And in this case, a lot of what you see in the board's decision is a finding that Judge Grendell was somehow biased or dishonest in how he tried to achieve the reunification. But the goal of trying to achieve reunification is not bias or dishonesty. That's implementing a court judgment. And
the board said he had a selfish motivation, right? So what was selfish about it?
Exactly. The argument they tried to make is one that this court rejected in Disciplinary Counsel versus Gall, which is that the selfishness is that he wanted to show that he could achieve the result, that somehow that would enhance his judicial reputation. He had no personal interest in the outcome of the case, nothing that would give rise to, the kinds of things that would require disqualification, right? He just wanted to achieve the goals that the domestic relations judge was unable to achieve. And that's not bias, and that's not selfish, and that's not dishonest. So that's a clear error. The board did not follow the instructions of this court in Disciplinary Counsel versus Gall, which really struggled with what does that mean, selfish and dishonest. And that gets to the other mitigation point, which is, and I see that I want to reserve a little bit of my time for rebuttal, but just let me make this last point, and that is that in this case, the board said there were multiple violations and a pattern of misconduct. But in reality, what we have is one case involving alleged errors of law, which we submit were not errors of law, but even if they were, they weren't willful errors of law. and then use that to put a fairly draconian sanction on a judge with a 46-year career of unblemished disciplinary record and dedication to public service.
What if, assume that we agree with you about the First Amendment, assume we agree at least in part about selfish motive and some of those other things, but we still think that there was conduct that violated disciplinary rules in detaining these individuals. What would an appropriate sanction be?
Well, there's two choices there, Your Honor. I do think that the Gorsyka case is a good example. That case, they did impose a public, they called it public censure, but it's essentially a public reprimand. And then you also have examples in which this court has, particularly with somebody that has no prior record of any disciplinary violation, of a stayed suspension, a fully stayed suspension. I think those would be the two minimum that would be appropriate here, because even if you find that there was some disciplinary violation relating to count one, that would be one, case out of a whole career, and it's not a ground for suspending the license. And in this case in particular, Judge Grendell is now in the middle of his, I think it's his third term, that'll expire on February 2027. So, and this is the first time that he's ever had a case involving a transfer from domestic relations court. So there's no real opportunity that this is going to recur again. So I'd ask the court to, first I'd ask the court to rule in Judge Grendell's favor that there were no disciplinary violations, but if to the extent there were, that either a public reprimand or a fully stayed suspension. Thank you, Your Honor.
Thank you. Mr. Caligiuri, good morning.
Good morning. May it please the Court, Chief Justice Kennedy, distinguished members of this Court, I'm Joe Caligiuri. I represent the Office of Disciplinary Counsel. I have with me at counsel table Senior Assistant Martha Asif. First, would like to address one of Mr. Funk's points that he brought up regarding count one, which was the illegal detention of the two Hartman juveniles, ages 13 and 15. Mr. Funk wants to paint a picture that this was simply legal error. But if you look in the board's 88-page report, 50 of which dealt with count one, you see how the board came to its conclusions that the respondent actually created, orchestrated, and fabricated trumped-up unruly charges as a method to illegally detain these boys solely so he could force them into visiting with their father, whom they hadn't seen in 3 years, and whom Judge Grendell knew that they legitimately feared. And that is a board finding after 9 days of testimony. We have a judge that actually manipulated and fabricated charges. And the way we know that is because we have the phone records that show exactly the chronology of events. Everyone involved in this case stated that the boys were not unruly. They didn't exhibit any unruly behavior. Even Judge Grendell testified that they had never, to his knowledge, ever disobeyed their mother. So it was just simply impossible for these children to fail to reasonably submit to the reasonable control of a parent by being habitually disobedient or wayward. When the judge was on the phone while the kids were at the drop-off on Friday evening, the phone records established that as soon as that his constable made a call to Judge Grendell stating that the mother dropped the kids off as instructed, she left, and the kids are now saying they're scared, they don't want to go see their father. And the judge at that point orders the kids detained. He issues he makes a phone call to his chief probation officer, Beth Williams, and he orders them to be detained. They had never disobeyed anyone at that point in time. Then he instructs his bailiff, his constable, to call the mother and instruct her to order the boys to visit with their father. And the judge knew that, he felt that the mother wasn't going to do that. He was playing a game. He wanted to set her up for a contempt charge. Well, the mother got on the phone and she encouraged her boys to go because the constable said if they don't go, they're going to jail. And we know that because the judge already ordered them to be detained. So this isn't legal error. This is a judge manipulating our system of justice to incarcerate or detain two children. We have never seen that in the state of Ohio, and it's completely antithetical of what we expect of our judges.
So I want to ask the question that Justice DeWine had just asked your opposing counsel. Setting aside the other two counts, if we agree on the First Amendment challenge, what is your position as to an appropriate sanction if we agree at least in part on count one?
Well, one thing I would agree with regard to my colleague's point, if you feel that the testimony in count 4 dealt with the law, the legal system, or the administration of justice, then we would not prevail on that count. But I would submit to this court that whether you find that or whether you find that he had a constitutional right to make the comments he did, it has absolutely no impact on the board's recommended sanction in this case, and I'll explain why.
Okay, so did the board, not the board, did disciplinary counsel, just like Justice Grendell has an obligation to follow the law, so does disciplinary counsel, did you make any inquiry into whether there was a constitutional? I mean, the law seems pretty clear cut here. This is a matter of public concern, which the Supreme Court has said that judges who are elected have a right to speak out about. It's a little stunning to me that in light of cases like the Minnesota case that the board would want to pursue this.
Well, Your Honor, if I may, this is not in the record, but yes, we did consult with constitutional experts before proceeding on this case. But the issue here is that we have a rule that this court has adopted that basically says and supports the Supreme Court's rulings in both Republican Party versus White and also Williams-Yulee, that basically says judges are not politicians, even if they come to the bench by way of the ballot. And this rule, 3.2...
It says that judges, it says that you cannot strip elected judges of the ability to speak out on issues of public concern. I mean, this seems to go much farther than the Minnesota Supreme Court's prohibition of whites here. I mean, this is core speech before a legislative body. I mean, if that's not protected, what is?
Well, we agree that this is different than White in that respect, because White dealt with the announce clause in a judicial campaign, and Williams-Yulee dealt with fundraising in a judicial campaign. We don't have that here. What we have is our own rule that basically states we want to ensure that the public has faith in the impartiality and integrity of our judiciary, of our judges. And so we've made this rule, 3.2, that basically says, which we believe is narrowly tailored to further the state's compelling interest in an independent and impartial judiciary, that basically says all speech is prohibited before a legislative body in this particular issue, unless it basically deals with your professional responsibilities or your personal legal or economic interests. And it's narrowly tailored. There are a lot of things you can testify about, but it has to be in connection with matters that concern the law, the legal system, or the administration of justice. And we would submit that
So when was the rule written?
This rule has been in place in Ohio since the adoption of the model rules, which I believe was in the late 70s. It's
Okay,
changed.
so Minnesota versus White, 2002?
Right.
Okay.
Yeah.
Thank you.
So every state that has a version of the model rules has a version of Rule 3.2. And the Arkansas Supreme Court, in which the respondent relied upon, they took a look at their rule, and that's the only time it's been challenged as far as we know. And in that case, it was really a vagueness issue because they had language that was in their rule that basically said a judge, one of the exceptions was a judge can testify about the judge's interests. And that created a standard list operation. Basically, it didn't tell the judge when they could and could not testify. So they then amended their rule, and now their rule mirrors our rule. And so we would submit that the exceptions are narrowly tailored to further the state's compelling interest. But getting back to my other point, because I understand certainly you're concerned with that, it's not going to affect the sanction, regardless of what you do. On a the scale of severity.
So I guess then if that's the case, why bring these charges? I mean, you know, if there's clear conduct that disciplinary counsel thinks violates the rule and thinks that's in of itself is the reason for the sanction, why bring these dubious, at least in my mind, dubious First Amendment claims?
Well, Your Honor, again, even if you do decide that it violates the First Amendment, the way the rule is written, or it concerns the law of the legal system or the administration
Or
of justice.
it could violate in the way it's been applied, too. I mean, rules, you know, rules can violate
Yes.
on their face, but they can also violate in their application, and that's, I think that's...
Again, our position on this would be that the subject matter of the testimony, which was the way the Department of Health reports COVID statistics, had nothing to do with the law of the legal system or the administration of justice. But I understand if you disagree with that. But it was also an abuse of the prestige of his office to advance his wife's interest. And even the cases respondent cites in his brief, there are situations in which, I think the Genevian case is one in which they did not find a violation of, they found First Amendment protection for speaking at a press conference that a judge had, but they also said because the judge used the trappings of his office, appearing in his courtroom in his robe, to address a more private matter, that was an abuse of prestige. And if you look at the judge's testimony before the legislature, this was nothing more than him lobbying for the passage of his wife's bill when she was in a contested election. So even if you don't find a 3.2, there's still a clear-cut 1.3. The board found that there was just no reason for this testimony other than to advance his wife's interest in having this legislation passed while she was in the middle of the
Isn't it possible that the judge also thought it was a good idea and it was in his wife's interest? I mean,
It was, but Rule 3.2 states, though, that, you know, even when you are appearing before a legislative body, that you need to keep in mind that your testimony might violate other rules, and the comments state 1.3 to be one of those concerns. Judge Grendell completely ignored that concern and went forward with the testimony. But getting back to the sanction, and why I say it has no impact on the sanction, you need to look at disciplinary counsel versus Bachman as a starting point. And in that case, our court said, anytime a judicial officer's misconduct results in a violation of it results in incarceration, which is a violation of the public trust, that requires an actual suspension from the practice of law. So right away, we're starting at 6 months. Then you look at disciplinary counsel versus rep. This is the same argument respondent's making. He's claiming that no prior discipline, this was only one case out of thousands. What was the same in rep? Rep had one case, 3 rule violations, where he ordered unlawfully a woman to be held in contempt who was simply a spectator in court doing nothing. Sentenced her to 10 days in jail. She was released after 1 day. A 1-year suspension was imposed by this court because we expect judges to follow the law. And when you're going to take someone's liberty away from them willfully and illegally, you deserve a stiff sanction. The harm that the respondent caused to these 2 innocent, straight-A students that had never been in trouble in their lives is staggering in this case. We've never seen a case like this. And so for the respondent to simply say that this was all legal error, that just highlights the reason why the board found that he refused to acknowledge any wrongdoing in this case. In fact, he stated if he was presented with the same facts again, he would he would detain these children again. They did nothing wrong. Nothing.
So I understand the argument about why this was incorrect. But why was it selfish?
The selfish motive was because the respondent said throughout his testimony and throughout his written responses that he was going to do this because he was going to succeed where other courts failed.
But is that really selfish? If that's selfish to want to succeed in something, then
But Your Honor,
it's hard to imagine what's not selfish.
I think you have to look at it in a way that aligns with his motive in this case. And his motive was not pure. His motive in this case was to force these kids to visit with their father, knowing that it was not in the best interest for them. And that's why the board found
He's not getting any personal benefit from that. I mean,
he's not, but as
I mean, he's not going to make him richer. It's not going to make him, it's not going to give him anything he doesn't have. That just seems a weird definition of selfish to say, well, I want to succeed at, someone wants to succeed at something or someone wants to accomplish what they're trying to do, so therefore they're selfish for that.
Well, I agree with the way you're looking at this problem. It doesn't jump out at you as selfish conduct that we would normally see in the traditional sense. But as you brought up in the Hoover case, you didn't preclude the possibility of reputational gain being a selfish motive. It didn't apply in Gall. We didn't get there on that case, and I understand that finding. But here, the respondent was blinded by this. And you have to consider it, in my opinion, along with the board's finding that he was actually operating with a dishonest motive because he
Wait a minute. You're a judge and you believe that parental alienation has been going on for years, and the question is the best interest of the children, and you believe that basing your knowledge of what the psychologist said and everything else, you believe that attempting to reunify children with a parent has a selfish motive or is dishonest?
I do, because if you look at
You understand that you're saying that every judge who's doing this today in a courtroom across Ohio, that they're being dishonest or selfish if they're trying to reunite families?
with all due respect, Your Honor, I do not think that's what we're saying.
Then what are you saying?
What I'm saying is the record in this case was that every single professional, every single person involved in this case, including the GAL, including Dr. F. Sarafard, including Jolene Sundquist, including the mother, including the parenting coordinator, everyone associated with this case, and of course, most importantly, including the children themselves, whom the judge interviewed in camera, stated that visitation with their father was not in the children's best interest. So respondent had no evidence, none, absolutely no evidence that it was in the best interest. And that's why the board was so moved by the fact that he was forcing these kids to visit with their father despite every professional involved with the case telling them that it's not in their best interest. So if there was a legitimate finding of best interest, a hearing, testimony, anything, we wouldn't be arguing this point. He did not take any evidence in this case. He never conducted a hearing in this case. The only information that you can consider formal in this case was his in-camera interview with the children, with each of the children. And all three of them let him know genuinely, the GAL was in the room and she testified genuinely that they feared their father and did not want to visit with him. And I know that doesn't control, but that's the only evidence that he had before him. So
what was the evidence why he ordered them not to be able to call their mother?
Because it was completely punitive. He claimed that it was because the mother was a victim of the alleged unruly charge, which he fabricated. But that was simply punitive. If you look at his response to the NOI, the Notice of Intent, which is Exhibit 186, he tells you why he put them in custody. He wanted to motivate them to see their father. And he wasn't going to let them call their mother, contrary to the law, for the entire weekend. And he didn't. Simply punitive. So I see my time is up. I would ask that the court adopt the board's recommendation and suspend the respondent for 18 months with 6 months stay. Thank you.
Thank you. Mr. Funk,
Thank you, Your Honor.
you have a minute, 2 seconds left.
All right, thank you. Just real quick points. He started off his presentation by saying illegal detention, and then he proceeded to argue that it wasn't errors of law. But throughout his presentation, he talked about errors of law. And there's just no evidence of any willful errors of law because there's case law supporting each one of Judge Grendell's decisions. With respect to the argument about manipulating and fabricating charges, this all happened very quickly in real time. So what's happening is there's an order by the court to do visitation. There's a call the children are refusing to go. Call the mother to see if she can persuade the children to go. At that point, they're still refusing to go. So that is unruly behavior. And we cited multiple cases that say that that's unruly behavior. So under the statutes, they can be detained based upon alleged unruly behavior. And that's the law. I mean, if they want to go to the General Assembly to change the law to make it harder for juvenile judges to detain individuals on unruly charges, they're free to do that. But Judge Grendell was following the law in real time, trying to make decisions that he thought was in the best interest of the children, which gets to the point about the evidence. This was an agreed judgment entry. So this is all implementing what the parents had already agreed to. They already had agreed that it was in the best interest of the children to reunite the children with their father. And that was explicitly based upon Dr. A's report, Dr. A being the shorthand for the name that I can't pronounce. But Dr. A's report is very, very detailed, and it's very, very explicit that the children should not be allowed to voluntarily sever their relationship with their father, that would cause emotional harm. So at this point, Judge Grendell gets the file, he reads that report, he understands what the parents agreed to, and now he's trying to implement that report. So he was motivated by the best interest of the
So
children.
is the agreed judgment entry one of the exhibits in the trial?
It was, yes, Your Honor, and I do cite it in our brief. And then finally, on the Bachman decision, he made the argument that Bachman means that any time you detain a child or detain a person illegally or improperly, that is an automatic 6-month suspension. That would talk about a chilling effect. That, if the court were to adopt that per se rule, that would create a huge chilling effect on judges. Every day, a judge in the state of Ohio has to make decisions about whether to incarcerate or detain a person for a day or an hour, whatever. And if they believe that they could be called to the carpet months, years later, and then automatic 6-month suspension, that would have a severe chilling effect. I would urge the court not to adopt that rule. Thank you.
Counsel, before you sit down, counsel, excuse me. Why prohibit the kids from talking to the mother?
Oh, Your Honor, I appreciate that. I want to answer that question because there is evidence in the record that there was a policy adopted by Judge Grendell's predecessor, probate court, that had been in place for years, that in any situation in which there is detention, there is not to be any communication between the person who is the alleged victim and the person that is. And in this situation, it was an unruly charge based upon the failure to follow the mother's instructions to go on visitation. So it wasn't a vindictive thing. He was trying to operate inconsistent with the established policies of the court that was put into place by his predecessor.
Is that in the record?
That is in the record, yes. And it's part of Judge Grendell's testimony. But
Is
let me,
the policy in the record?
I believe it is, but I can't say for certain, but I believe it is. There's a lot of exhibits in the case, but
Is it your interpretation of that policy that would also apply to the grandmother and the sister?
I don't know, Your Honor, the answer to that question. I do know that Judge Grendell allowed their priest to come in. He also allowed their attorney to come in and visit with them. So I don't think he was trying to be vindictive. He was trying to follow what he perceived the standard policy was and not deviate from it. So I hope that answers your question. Thank you.
Thank you. We'll take the matter under advisement. You'll receive a decision from the court.